we have been talking on this program literally for a couple of years anyways, when Mark Udall and Ron Wyden were making their concerns, and maybe I'm understating this, that the U.S. government was interpreting the Patriot Act in particular in a way that most Americans would find shocking, in a way that they felt was unconstitutional. Through that time, we have said that the implications of this are essentially that there is secret law. And for the past couple of weeks, in the wake of Snowden's revelations, this has been the primary issue as far as I can tell. We still don't know nearly all there is to know about this NSA surveillance. Its potential for abuse, it's already being abused. But what is clear is that there's abuse in the sense that there has been set up a completely unaccountable, a completely opaque regime of secret law, which in and of itself is an abuse of the law that Congress has passed. There is no other example in our system of government. In fact, I would argue this is not even within our system of government. This is outside our system of government. It is fundamentally anti-democratic. It is quite possible that these laws, Section 715 of the Patriot Act, the FISA Court amended law passed in 2008, could be adjudicated in front of the Supreme Court. It could be found that the NSA, the FBI, et al. Are operating under the auspices of these laws in a way that does not contradict or run afoul of the Constitution, particularly the Fourth Amendment. And then the public would have the opportunity to react via their representatives, via their power in elections. But we don't have that here. All of this could be found to be legal. I still would have a problem with it. But that's very different than to say that this body of law, which supposedly allows the NSA and the FBI and whomever to engage in these activities, is legal because we don't even know what the law is. And now that the New York Times apparently has gotten some additional documents and additional sources and has finally sort of picked up this angle, hopefully there'll be more attention paid to it. And right, in more than a dozen classified rulings, the nation's surveillance court, this is the FISA court, has created a secret body of law, giving the National Security Agency the power to amass vast collections of data on Americans while pursuing not only terrorism suspects, but also people possibly involved in nuclear proliferation, espionage, cyber attacks. And frankly, we don't know what else. We don't know what the definition of a terrorist is. As far as this court determines what it is. We don't know what the definition of, and we will talk about this as we get further in the piece, but essentially the FISA court has unilaterally, outside the system of law that we have in this country, created and expanded the exceptions to the Fourth Amendment. And we don't know really the full breadth of what those exceptions are and for whom they are what agencies and what they have to prove to be allowed those exceptions. We don't know that in the present, and we don't know that in the future. We have no sense where it can go. We can't even speculate on it. And that's because all this is done in secret. The rulings, some nearly 100-page long, reveal that the court has taken on a much more expansive role by regularly assessing broad constitutional questions and establishing important judicial precedents. I don't know under what authority the FISA Court has the ability to do this. I don't know if you can even statutorily imbue a court that is subsidiary to the Supreme Court with this ability. As far as I know, the Constitution only allows for the Supreme Court to make final adjudications on the constitutionality of these issues. There is no way, at least as far as we know, and certainly if history is an indication, there's no way for any of these cases to be appealed to the Supreme Court. It is created a parallel system of courts in this country. And unlike the Supreme Court, where you have both a plaintiff and a defendant, here you only have a plaintiff. Only the government comes and makes its case. There is no one who makes the adversarial case. And we have an adversarial system of law in this country. This is stunning. And this is a court that was set up specifically to approve case-by-case wiretapping orders. This was set up as a magistrate, essentially. A federal secret magistrate, providing some oversight on a case-by-case basis, saying whether or not this conforms to the law. Even then, it was fairly close to as rubber stamp as you could get it. But when a court rules on something, when it makes a precedent, it becomes the law until it is challenged in a court that is higher than it, essentially, which is why these cases wind their way up to the Supreme Court, or the Supreme Court rejects them because they don't see a significant enough problem for them to deal with, and it ends at a federal appeals court. We don't have this system here. One of the court's most important decisions, the judges have expanded the use in terrorism cases of legal principle known as the special needs doctrine and carved out an exception to the Fourth Amendment's requirement of a warrant for searches and seizures. Now, maybe they have and maybe they haven't expanded that special needs beyond terrorism. Maybe they have and maybe they haven't expanded the definition of terrorism. We know that if you chain yourself to a tree and you block a pipeline, there are agencies that put you on a list of terrorists. You're an eco-terrorist. We know that, at least coming out of these fusion agencies, we know that at least some federal officials perceived Occupy protests in the same way that they did potential terrorist threats. We don't know if this information can be accessed based on this special need to make sure that these protesters don't get out of hand. We don't know. The special needs doctrine was originally established in 1989 by the Supreme Court in a ruling allowing the drug testing of railway workers, saying that you can have a small intrusion into the privacy of these railway workers if the government needs to fight an overriding public danger. In other words, that you may get a train accident like they just had in Quebec. Well, I don't know that that was the cause of it, a function of impairment by the train workers, but that's the idea. And so the FISA Court has ruled that the NSA's collection and examination of Americans' communication data to track possible terrorists does not run afoul of the Fourth Amendment. I mean, I just don't know under what authority the FISA Court is operating to adjudicate these things. Now, you should know that the FISA Court consists of 11 judges appointed by the Supreme Court, the Chief Justice of the Supreme Court. The fact that they're all Republican, the fact that the Supreme Court, that John Roberts has the ability to cherry pick judges to sit on this court to hear a specific genre of cases is problematic enough. I would still have a problem if it was Justice Ginsburg sitting on as the Supreme Court Justice, picking 11 Democrats to specifically hear this. If this court was adjudicating things and creating law, I have no problem with courts creating law, it's just that it's done in a completely parallel track, and there is no ability to appeal it, and there's no one there to argue why this is a bad idea. I mean, talk about judicial activism. This is just absurd. And then there are quotes from a couple of legal experts who basically say, this seems like a legal stretch to me. Again, the two issues here are that does not seem to be redress. There does not seem to be parties to call for redress. There is no two sides to the argument here when the FISA Court hears this. It is incredibly problematic. And the silence from the legal establishment, again, is just, it's deafening. I mean, why is it only places like the Center for Constitutional Rights? Why is it only the Brennan Center? Where is the American Bar Association? Where is every single legal institution in the country on this? It's I want to say stunning, but I know I overused that word, but it's shockingly stunning.
In an unbelievable way.
In an unbelievable way. The Wall Street Journal has what can be read as a companion piece to this, digging deeper into one of the rulings by, or a body of rulings by the FISA Court, wherein it redefined the word relevant as to what the FBI could seek and get in the course of an investigation. Now, even I think the word investigation in this case is also incredibly malleable. What is it are they investigating? There's been no crime committed. They are not investigating. They are essentially trying to profile people. They are trying to find a class of people. They're not investigating a crime here. Right? Because the crime has yet to take place. In classified orders starting in the mid-2000s, the court accepted that the term relevant could be broadened. And when they say accepted, what they're saying here is that the FBI or some other agency petitions the court, essentially, saying we need the term relevant to be broadened. And essentially, it's just the court deciding on their own. People with, I mean, do we really know the extent of what the expertise of these judges are in these cases? I don't know who is writing them briefs to argue that you shouldn't increase or broaden the meaning of the word relevant. Could be broadened to permit an entire database of records on millions of people, in contrast to a more conservative interpretation widely applied in criminal cases, in which only some of those records would likely be allowed. In other words, relevant means something in legal and criminal legal terms. It has already been defined through decades, maybe centuries, of criminal law. And this court, without the benefit of anybody making the case as to why it has been limited to what it's been limited to, accepts the petition to increase the definition, to expand the definition of the word relevant. Really to the point of where the word relevant has no relevance. Relevant is supposed to be a word that you apply to a set of information that limits it, right? It is a qualifying adjective. When it no longer reduces that which you may hoover up, I guess, it ceases to mean anything. And that's just in colloquial terms, but in legal terms, it means something very specific too, and it clearly means something narrower than what this court has unilaterally decided it's going to mean. The court's interpretation of the word enabled the government, under the Patriot Act, to collect the phone records of the majority of Americans. Relevant has long been a broad standard, but the way the court is interpreting it to mean, in effect, everything is new, says Mark Eckenweiler, a senior counsel at Perkins Cole, who until December was the Justice Department's primary authority on federal criminal surveillance law. I don't know that this guy had the opportunity to argue against whatever case it was or whatever the motion was filed. But it sounds like if he did, he lost. Two senators on the Intelligence Committee, Ron Wyden and Mark Udall, have confirmed that this aspect of the word relevance is what they were talking about. Or at least it's been confirmed by members of their offices. In 1991, the Supreme Court ruled on what the term relevant means. And it means if there's a reasonable possibility, that's in quotes, that those things will produce information related to the subject of the investigation. Now, as it's written here, it seems to mean the person or individual or crime that is being investigated. But in this instance, there is no person, no specific person, no specific crime that is being investigated. In criminal cases, courts have previously found that very large sets of information didn't meet the relevance standard because significant portions, innocent people's information, wouldn't be pertinent. But the FISA Court has developed separate precedents centered on the idea that investigations to prevent national security threats are different from ordinary criminal cases. And then, of course, the issue is, what constitutes a national security threat? Again, we're back to this problem. The court's rulings on such matters are classified and almost impossible to challenge because of the secret nature of the proceedings. So we have this body of secret law that seems to be systemically impossible to know or to challenge. This in and of itself, regardless of what the NSA is doing with this stuff, regardless of the opportunity for corruption, this in and of itself should be enough to re-examine the whole infrastructure that has allowed for it. This in and of itself, the knowledge that, and because while we were speculating about this, Snowden's revelations have at least opened up the floodgates a little bit, so that now we're seeing these stories in the Wall Street Journal and the New York Times. It's nothing that we haven't been saying on this program for quite some time. And it's nothing that we didn't know in the context of, Terror Tuesdays. But, God, I don't know what it's going to take for at least the legal establishment to say,
Maybe we have a little bit of a concern with massive precedents and common law being set without it even being adjudicated properly. Maybe
there
that's
is
a
no
little bit
system
of a concern.
law in this country if this is let to be is allowed to exist. There is no system of law. It's meaningless. And why not just set up a whole series of other courts? I mean, this cuts both ways. One, why just have this exception, for these investigations? Why not for all crime? I mean, we don't know what constitutes national security. I mean, is this an existential threat? How many people need to be killed for it to reach the level of national security? We don't know. Presumably, there's some finding by the FISA Court as to what constitutes national security. They apparently can come up with their own findings on all of these terms. And why not? Why not have a separate system to deal with environmental law? The Supreme Court justice can appoint those judges to just unilaterally decide without having any type of adversarial case in front of them. I mean, this is going in, then the king just decides. But in this case, he's farming it out to the dukes. It's really stunning to me. And I think, one of the things that bedeviled me in my short legal student career, and perhaps which set me up to be completely disillusioned by my time at law school, was just that, I grew up in with a family of lawyers, and there was a little bit old-fashioned-y, and the whole notion is that law is the glue that holds our the fabric of our society together, and that lawyers had a higher duty to society to make sure that the system of law was above reproach. I mean, I think this is why it took me so long to get over the 2000 election. Because it was clearly and nakedly not a legal or a decision that was made not through any sort of accepted legal process and norms. And this is the same. I mean, this cuts fundamentally to our system of law in this country. And it's just stunning to see the silence by the legal community. And I'm not talking about those people whose jobs it is to advocate against this stuff. I mean, I just don't know how you can go into your law office today and think what you're doing is anything other than just simply transactional, as opposed to based on a system of law. It's just, I just find it stunning.